ladies and gentlemen, I will make the point further clear with the help of example. On this point, the testator must be competent, must be of sound mind while making the will in respect of his property. And not only he should be a person of sound mind at the time of making the will, rather after making the will, he should remain person of sound mind till his death. In case will is made on a particular date by a particular person in the name of a particular person of certain portion of his property. For example, H is a testator. He is a testator. Means he is a testator. H is a testator, owner of the property. On a particular date, say for example on 1/1/2020, he wanted to dispose of his certain property by means of the will or by means of the bequest, and the person chosen for this work for making the will was, say for example, A. H, a testator, and the person who is proposed to be the beneficiary under this will is A, therefore A will be legatee. Here A will be legatee. H a testator and A the legatee, because H is going to dispose of his property, proposing to dispose of his property on 1/1/2020, and the person chosen for giving the property is A in the given example. Now he makes a oral declaration to the effect that 1/3 of his property, or he says that out of the property, A will be given rupees 20,000. Means H made a will on 1/1/2020 in the name of the legatee A, and the amount of the bequest in this case example is 20,000. Now the first and foremost condition for a valid will required under the Muslim law is that on the date on which the wasiyat is being made by declaration, on that very particular date, the testator H should have been a person of sound mind, means he should have been capable of making a rational decision in the estimation of law. Means he was fully aware of the nature and consequences likely to follow of this declaration, which will amount the wasiyat in the name of A by H. And not only this, even after making the wasiyat on this date, he should continue to be a person of sound mind. He should continue to be a person of sound mind. And he should continue to be a person of sound mind till his death. Say for example, he died on 1/1/2021. After 1 year of the making will, on 1st January he made the will, on 1st January 2021 he dies. So in between 120 and 21, throughout he should have been a person of sound mind. Say for example, on 1/1/2020 wasiyat was made, but on 1/6/2020 he became of unsound mind Due to the mental illness or attending facts and circumstances, he became insane, incapable of making the rational decision due to his mental and physical illness, and in the state of insanity he dies on 1/1/2021. Now here in this case will not be valid, because at the time of making the wasiyat he was valid, he was sane, person of sound mind, but after 6 months of making the will, he became ill, and pursuant to the illness, he lost his mental balance, cognitive faculties, which rendered him incapable of taking the rational decision, means he became a person of unsound mind. And in the state of unsoundness, he dies after 6 months on 1/1/2021. Wasiyat will not be valid, because the rule is that he should, after making the will, he should continue to be in the state of soundness of the mind. Likewise, if on 1/1/2022 he was not in a fit state of mind due to the attending facts of medical reasons, but wasiyat is made by him in the name of the A, and in the same state he dies, wasiyat will not be valid, because requirement is that person making the will on a particular date should be in the fit state of mind. Fit means must be of sound mind, and sound of the explanation sound of the mind in context of the wasiyat means he should have been capable enough to assess rationality of consequences likely to follow from the making of the wasiyat. This is necessary. This is necessary. Otherwise, will be invalid if it is not so. So, fitness of mind is a necessary condition for the validity of a will. So, this is a condition that person making the will, that is the testator, should have been a person of sound mind, and soundness of the material point to prove the soundness of mind is not only when the wasiyat is made, but will be required to be established that after making will he remained person of sound mind throughout the period till his death, because that will is operated only after the death of the same. And this requirement is, there is a philosophy, ladies and gentlemen, why soundness of the mind is necessary at the time of making the will, and not only at the time of the making will, rather the testator must continue to be a person of sound mind till the death, his death or her death. Reason is that it is the individual decision of the owner of the property. And this individual decision vary from time to time and circumstances to circumstances. On a given point of the time, he may be pleased with A, H could have been pleased with A, or could have been influenced with A, and therefore he took a decision to enrich or to make the economic condition of the A better in future. He makes a declaration that out of his net total property, rupees 20,000 should be given to him as a part of the bequest. Now, on 1/1/2020, taking into account the condition of the A, taking into consideration the services rendered by A taking into consideration the personal relation of A with H decided to give away certain part of his property by means of the bequest to A, that he makes a declaration that certain portion of the property would be given to A after his death, means he made a will in the name of A and A is the testator. Now, on the date when he made this type of the declaration, he was a person of sound mind, he was in good state of mind. But after some time, he must be capable of rethinking, because if there is a change in the situation of A, so with the change in the situation of A, H also may take a different decision, can change his decision. If after making the will, testator become insane and continues to be insane, means he is deprived of his power of rethinking over the decision which was already taken in a different circumstance. Since he was deprived of taking giving the rethink over his decision which was taken in little bit past, may result deprivation of the other legal heirs after his death. Therefore, rule is that after making the will, the testator should continue as person of sound mind. If this is not safe, so means he was deprived of, because it is within the power of the testator to revoke the will at any point of the time before his death. But after making the will, he become insane, continues to be insane. So how can he take a fresh decision? How can he exercise the right to revoke the will? This may not be possible. What he did, he is incapable to rethink over it, and that may be fatal to his legal heirs after his death, because the condition of the A might have improved, economic condition of the A might have improved, and economic condition of his legal heirs may likely to depreciate. So this situation he should be in the state of mind to keep in the to take the cognizance of all these situations, and therefore it is necessary that throughout period after making the will till death, the testator must have been a person of sound mind. Ladies and gentlemen, the next point is that he should have attained the age of majority, because testator must be competent, and to be competent he must fulfill the two basic conditions, that he was person of sound mind at that time of making will, and at the same time he was of 80, he has attained the age of majority. So majority is also one of the condition for a Muslim testator to be competent under the law. Therefore, the other condition for a Muslim testator under Muslim law is that he must, at the time of making the will, should be major in terms of his or her age. According to Muslim law, person becomes major on the completion of age of 15 years. And this was the state of situation till 1875. Means till 1875, anyone who was a Muslim was regarded minor until he attains the age of 15 years. As soon as he completed the age of 15 years, he will become a major and was competent to make the will of his or her property before 1875. In 1875, Indian Majority Act was passed, and the age of majority under this law was fixed 18 years. Ordinarily, and in case of guardian, appointed by the court for a minor, such person attains the age of majority on the completion of 21 years. Since this act applies to all the Indians who are domiciled in India, including the Indian Muslim, in conformity with the provision of the act, a Muslim must be 18 years old before he can make a will under Muslim law. However, where the court has appointed someone as guardian for the person or property of a minor, or where court of Wards Act has assumed the superintendence of the property of minor, such minor will attain the majority on completion of 18 years. Since this act applies to all the Indians who are domiciled in India, including the Indian Muslim, therefore, for the purpose of the will, this age of majority given under Indian Majority Act superseded to the age of majority as given under Muslim law. So now for the purpose of the will, even under Muslim law, the age of majority is 18 years, not 15 years. This should be clearly understood. Dear learners, now I come to the next prerequisite of a valid will under Muslim law, that is the second condition necessary for a valid will under Muslim law. That is, legatee should be competent to take the bequest, as testator should be competent to make the bequest. In the same way, a legatee should also be competent to take the bequest. Here expression legatee should be understood. Legatee. A legatee means person or set of the persons who are beneficiaries under a testament, meaning thereby that the beneficiary or beneficiaries under a bequest or deed of the will, wasiyatnama, are known as legatee under a will or legatees. Now the requirement is that the beneficiaries, proposed beneficiary under the will, should also be competent to take the bequest. Now, who are competent legatees? Under Muslim law, legatee can be any person, and here person means biological person, and person may also be the artificial person or juristic person, because a person is a wider term under law, includes both biological persons as well as the artificial or juristic person. A juristic person may be a school, college, institution, corporate, NGOs, means any legal entity capable of holding the property is said to be the legal person. So under Muslim law, legatee or beneficiary under the will may be any person, biological or juristic. As if the person is biological, sex and sex is also immaterial. Means legatee under a will may be a male, as a male can be, in the same way a female can be. Not only male and female, even the sect is also immaterial. A legatee may be a Muslim, may be a non-Muslim, even may be atheist. But in case where the will is made in favor of any biological person or juristic person, requirement is that legatee should not be involved in the campaign against the Islam, or he should not be on the face of record hostile to the religion of Islam. Therefore, a person who renounces the Islam, embraces another religion, say for example Christianity, or he becomes a Jew, or he becomes a Hindu, he will not be a competent legatee or a person legally entitled to avail the benefits pursuant to a bequest made in his name or in his favor. But a person who was born into a religion other than Islam, say for example a person was born in a Christian family, and by nature by birth he is a Christian, he is following the basic or fundamental rituals of the Christianity. He is a normal Christian, and in case the bequest is made in the name of such person, so he will be the beneficiary after the death of the testator. But since on the face of the record he is not involved, or he has not been involved in any act against the Islam, or which is hostility, which demonstrates the hostility, then such person will be deemed to be a will be lawful. A legatee means he will be entitled to be a legatee in a bequest. So, and in the same way, suppose a bequest has been made by a person of his property in favor of an institution, and the institution is engaged in imparting the secular education or a normal education. Say for example it is engaged in imparting the medical education, so it can be a good legatee. But if there is an institution which is engaged in promoting the ideology of any religion other than Islam, then it means that he is hostile to the religion of the Islam, and therefore he cannot be a lawful legatee. There is a difference of opinion on this point, but general rule is that according to the Hanafis, any person who is hostile to the religion of the Islam cannot be a legatee, though otherwise he may be competent. So, competent legatee should be competent, means the person or set of the persons who are beneficiaries under a will should be legally qualified or legally entitled to take the will. And to be competent, the legatee must be capable of holding the property given by means of the wasiyat. He must have been capable of holding the property. And therefore, to be capable of property, it is necessary that the person who is beneficiary or legatee under a will should be in existence, on the date on which the wasiyat is made.